go on to college, or even to get a meaningful living wage job. This is the problem that is a problem across this Connecticut for thousands of students in many schools. And we believe that this court should exercise the kind of reasonableness determination to determine if the principle of free public schools enshrined in this Constitution in Article 8, Section 1 is indeed being met. Instead, the state seems to argue that the word schools doesn't have any meaning, and that because there's not an adjective in the text, even as there are no adjectives in many of Connecticut's sister states, which has found a right, because there's no adjective, this court should not recognize that the word schools has inherent meaning. To use a little bit of an analogy here, this would be similar to the right to counsel that the federal courts have recognized. The Sixth Amendment simply says that to have assistance of counsel for his defense. Now, certainly this means more than just having a person in a suit and tie stand before you. It means something substantive. And as the Supreme Court has held, this is a right to adequate legal assistance, and has used precisely the kind of reasonableness determination to determine whether that assistance is within the substantive content envisioned by the Sixth Amendment of the Constitution.
Well, counsel, how did you settle on the word, I don't mean your own process, but why suitable? Because we've been banding around other words too, like reasonable and adequate and good and so on. What's the significance of that, and does it matter?
As my co-counsel mentioned, we don't believe that it does matter, Justice Schaller. So as many other states have used different words, from minimally adequate to sound basic, we chose the word suitable, not because necessarily it was within Section 10.4a of the state statute. So we're not making the argument here that for some reason that it was in the statute, this should somehow create an independent constitutional obligation, as it seemed was the case with the plaintiff's arguments in the Broadley case. But rather, we are making an argument that the principle of free public education has inherent meaning, that you can describe this as suitable, you can describe this as adequate, but no matter how you describe it, the purposes of public education are clear. And these purposes are to prepare students to, after graduation, be able to get a job or go on to college, to be able to be effective citizens within our democracy.
But if a court does find an implied modifier, the court has to settle on a word, and why is that better than others? Or do you have another suggestion? I know you're trying.
Well, suitable is actually a synonym for the word appropriate, and so to the extent, and suitable also means to be adequate for the purposes of. So, we believe suitable could be an appropriate word because it's directed towards the purposes of education, the purposes that we define as our constitutional right in paragraph 46 of our complaint. But again, we are not set on a single adjective, and think this court, as the court recognized in McDuffie, that it's not the adjective that's important, but rather the intent and meaning of public education and the intent of the framers in the Constitutional Convention. And so this goes to the point of, again, of what is a school, and every word in the Constitution should have meaning, and what is appropriate legislation to implement the principle of free public schools. The state seems to rest its arguments on the words free or public, or seems to suggest that a school can be anything that the state deems it to be. But we simply disagree. And to reach this decision at this stage, given the motion to strike standard that all facts should be read in favor of the plaintiffs, no set of facts, no matter how egregious, would have to be found to upset this constitutional principle of public education that's been enshrined in Article 8, Section 1, despite the many factual materials that are within the amicus briefs in this case, within our own brief, which I would recognize are not necessarily appropriate at the motion to strike stage, but do suggest some of the egregious conditions that are present in the school system.
Counselor, if we were to agree with you on the standard, would you acknowledge that the state would have broad leeway in determining what in fact is suitable?
Yes, we would. So just as the legislature has broad discretion when providing educational opportunities that are above the constitutional floor, we believe that there are innumerable ways that the state could choose to enact policies that provide for these educational opportunities. The factual elements that we list in paragraph 53 are simply a list of a number of different factors that the legislature and the state can choose from in deciding how to create educational opportunities that prepare students for these purposes. And courts in other states have recognized that, you know, the legislature may choose to have smaller class size or use its resources to hire higher qualified teachers or do any number of policies to reach this goal. So we do not believe that the definition that plaintiffs seek would in any way limit the flexibility of the legislature and the school boards to provide these opportunities. The only way in which it would limit the flexibility was if, indeed, we could prove as a factual matter these opportunities were not being provided. It's also interesting to note that while the state seems to have this principle that so long as the school is labeled a school, that it meets constitutional principles, it's also interesting to note that it does not seem that they disagree with any of the purposes we've set forth for education as being part of our constitutional definition. So it seems that they agree that education should prepare students to function productively as citizens. Nowhere in their presentation today have they challenged that definition. Nowhere in the 50 pages of briefing they provide to this court or the hundreds of pages of supplemental materials. And the reason that is because there is broad agreement among all three branches of government in Connecticut of the purposes education is meant to serve. And the enactment of Article 8, Section 1 in 1965 brought these from being merely discretionary purposes of education or aspirational purposes of education to being constitutional purposes of education. And that is an important difference, we believe, for this court. Whereas before, the state cited to, I believe, the Bissell case, which recognized that it was the state's duty to provide this education, doing so because it was not part of the Constitution. After 1965, this changed, that it went from being a discretionary state duty to being an affirmative constitutional duty. And this is significant, as the court recognized in Moore, specifically looking to Article 8, Section 1, to say that recognizing such hortatory meaning would be inconsistent with a very serious principle of constitutional amendment. And we would agree with that statement in Moore. If I could just go to Moore to talk a little bit about this, this issue of equality and adequacy. We agree that these are two principles that complement each other well. So while the equality principle simply looks at the disparities between the breadth and quality of educational opportunities between districts, it doesn't say where that falls on the scale of what kind of opportunities are actually being provided. And so those disparities, in some cases, may fall below what is actually necessary to prepare students to, upon graduation, participate in their communities. And so the idea that we're bringing forth in our claims is that there must be a constitutional floor. So not only must there not be large disparities, but the educational opportunities provided actually have to fall above the constitutional floor of what the principle of public education in Article 8, Section 1 means. And indeed, we also would agree that the principle of adequacy seems to be one that is inherent in the very concept of equal. And as Your Honors noted, there's an important choice to make in determining what factors to compare. Whether it's equality or adequacy, the court is going to have to decide which factors are important for an education. In Horton, this court listed 8 factors: teacher quality, class size, educational resources and materials. These are the same type of factors that we're asking this court to look at to adjudicate whether an adequacy claim, whether the state is fulfilling its affirmative constitutional duty to suitable educational opportunities. And it also raises an interesting point on the justiciability question. So, as Your Honors mentioned, it's possible that the constitutional standard of equality may actually be